for allowing us to explore the issues here today thoroughly. I would submit that if there were not instances where someone was charged with murder, if all people who are charged with murder, aggravated murder, should be held, then the statute would say shall. It's the fact that the shall provision, which we find so spread through all of our rules, but the fact that shall is not there means that there are instances where people commit these offenses where they still should get a bail. And as tragic as this is, today showed us that there were really circumstances here that point to the fact that we're not dealing with a cold-blooded murderer who poses a threat to those around her. And this would not have occurred, certainly, Your Honor, what we hear today is most likely. And I agree with the prosecutor that there will be further evaluations and so forth. But I think it's a safe statement to make that this would not have happened but for significant mental health issues. What they were, that'll be detailed on another day. But the fact that they existed, everyone, even in their career-based experience, felt that there were mental health issues present. And so the questions that arise when I look at Revised Code Section 2937.222, again, I hone in on the word committed. And I'm not going to get into you understand why I said that before. But I bring in all of the facts that we heard today about all of the mental health ailment, whatever the word may be, that's my word, which was undergoing. So where best to treat that would be at a facility that treats mental health illness. And I totally agree with the prosecutor that there's been no evidence to suggest that how she acted at the hospital. We heard about what was heard and so forth. But the burden being on the state is that they had to show that there is no other reason. Not that it had to be shown that there were alternatives, but it had to be shown by clear, convincing evidence that there were no release conditions that would reasonably assure the safety of that person in the community. There is nothing to state that she did not do well at the Cleveland Clinic. There's nothing to state that at all. That burden rests with the state to show that if it did. She never posed a risk before. By all accounts, this was an isolated incident that came as a result of what was going on in her mind. I think to say that there are no release conditions, I think that's a little too far. Because she did do fine. There's nothing to suggest she didn't at the Cleveland Clinic. She's doing fine now. And so when she's getting the care, when she's getting the regimen, when she's getting medication, and if she were able to get the care of mental health professionals to the level that she's going to need, because we're talking about conduct that quite likely constitutes that of not guilty by reason of insanity. And with all due respect, the jails in Ohio and throughout this country don't have the resources to treat that level of illness. The facilities do. So you would ask, Your Honor, what do we suggest? I don't suggest that Ruth be just released back to the public. I do not suggest that an ankle monitor is sufficient. I don't believe it is until Your Honor is supplied with additional information. That information would come from an inpatient facility, and an inpatient facility could include institutions like going back to, well, actually, what I'd like to do, Your Honor, is give you the general, what we're seeking, and if the court is amenable to it, what I would ask to do is to notify the court under seal of exactly the place that places that she would go. It just makes more sense, because part of this is also, once it's determined appropriate by the inpatient treatment, and that's after they have substantiated medication and the counseling, that should be stepped down only by court order to release with home arrest, not just GPS monitoring. And also that in combination with outpatient treatment continue. So what this looks like, again, because I did say that rather confusingly, is going to inpatient treatment, whether that be the clinic, Recreate Ohio, Highland Springs, Sunrise Vista Behavioral, that can be done with a ankle monitor, if that needs to be. And then if there comes a point where the hospital says that she is stable, that she does not pose a threat, and we have the battery of documentation to support that, we would come back to the court to ask for movement from there to a address with family members. Again, I'll disclose that if the court would like it now, where I could certainly put it under seal, but locally, family members with house arrest and with continued outpatient treatment. As to the bond, I understand the magnitude of this offense. I would not be asking for a $100,000 bond or a $250,000 bond. Of course, I'm not going to join in a request for a high bond, but I also recognize that to have some semblance of credibility, I also have to be realistic and not suggest that a low bond is appropriate here either. So what that does is that then vests the family, who she clearly cares about, and they clearly care about her. If they are invested in this, this is just another incentive for her to be present. And prosecutor's correct, we do have to look at the general principles of bond to protect the community. There were no, other than this, when there was a break that has been described as delusional and detached, there has been no other instance of any sort of misconduct or certainly violent behavior. The community would be protected in the supervisory role of an inpatient facility where she would stay unless and until Your Honor would have determined that she was an appropriate candidate for the home release with the monitoring. As far as the appearance is concerned, there's nothing to suggest that she would flee. The discussion of her running for 30 minutes, that was addressed 3 times today with the ranger and then both the sheriff and the captain. No one understood why she was running. This may very well have been nothing more than a continuation of her role in the delusion that she was living in at that time. And I had asked specifically of the ranger first, was she praying? Was she going to go to heaven? Nobody knows that. So it therefore should not be used against her as some evidence that she's going to pose a risk of flight. Certainly not with the precautions that we can put in place as far as monitoring and so forth. This is a really, just as all cases are, but this is a really important case where there needs to be constant communication between client and visits, and something more than what can be done just by phone, even though I fully recognize that the court is giving private phones and so forth. But in our experience, Your Honor, one-on-one visits are critical. To have her at a place that's closer to where counsel is would be exceptionally helpful. And that would be a place that is safe for her and safe for others. So for all those reasons, Your Honor, given the outline, I would give the specific destinations upon request of